Thanks for joining us for the third installment of the Legal Linkup Summer CLE series. So, you may be wondering, what is the Legal Linkup? Well, we enjoy connecting with our colleagues and friends. So, in 2019 our firm hosted the first event. It was a networking mixer, firm launch, and appreciation day, all rolled into one. It was a great opportunity for our friends to get to know each other over dinner and drinks. In 2020, we couldn't gather because of the COVID pandemic, so we sent everyone a little postcard to let them know we were thinking of them, and because everyone was on Zoom, we sent a cell phone stand as a small gift. Now, it's 2021, and although things are getting back to normal, we felt this virtual CLE series would be a great way to connect and help enrich all of our practices even more.
Good afternoon. Welcome to the third installment of the Terrell and McCants Legal Linkup Summer CLE series. This one is Can They Do That? Employment and Workers' Comp Cases. On behalf of my law partner, Chris Terrell, and our staff, we want to thank you for attending. We have a lot of useful information in store for you. Our topic today is, like I said, Can They Do That? Employment and Workers' Comp Cases. We're going to delve into a couple practice areas that can have ripple effects on the lives and livelihoods of working people all across the state. And we're going to look at some things in these areas that you may or may not know as it concerns workers' comp and employment discrimination cases. I'm Terrell McCants with Terrell and McCants, and my law partner, Chris Terrell, and I primarily handle civil rights, employment discrimination, and criminal cases across the state of Alabama and beyond if necessary. And today we have a special guest with us, attorney Bernard Nomberg. Now, Bernard is our firm's go-to guy for workers' compensation cases and questions. He's a founding partner at the Nomberg law firm. He has been practicing law since 1995. I was a freshman in high school then, Bernard. His practice concentrates on workers' compensation, Social Security, disability, and personal injury. Bernard has served as the chair of the Alabama State Bar Workers' Compensation Section, and he's a member of the Birmingham Bar Workers' Compensation Section. And lastly, a fun fact about Bernard. He played quarterback at Vanderbilt University in the 80s. And he told me this story the other day. He was the holder for field goals, and they were going to run a fake field goal against Alabama, my Crimson Tide. And Bernard was close. He almost threw a touchdown pass on that fake field goal. And that's as close as a Vanderbilt quarterback has gotten to throwing a touchdown since.
Oh, you really want to start off on a good foot, don't you? Terrell, thank you for inviting me today. This is going to be a lot of fun.
Thank you so much for coming and doing this for us, Bernard, and coming to share your wealth of knowledge that you have on these subjects. And so without further ado, we're going to get into some questions. We're going to kind of pick Bernard's brain today. First, tell us a little bit about yourself, Bernard, and your practice.
Well, sure. And I appreciate the opportunity to be here. You and Chris are good friends of ours, and I've been glad that the last several years we've gotten to know each other a little bit, do some business together, socialize a little bit. And like you said, my law firm is the Nomberg law firm. We're based in Birmingham. My brother David and I run it. Our dad really founded it. He's happily retired down on the Gulf Coast, but we keep him in the loop a little bit on phone calls. But we've got 4 lawyers here at our practice. Social Security disability is one of them. The work comp is really our forte. Social Security disability, a little personal injury. We've added Steve Altman joined us this past year. He does bankruptcy. Steve is a fantastic bankruptcy lawyer. So that rounds out our practice. But where you and I and Chris have kind of intersected is really in the world of social media. We belong to the same marketing groups with lawyers, and we interact on a monthly basis. And that's really where you and I and Chris really, that's our space where we communicate quite a bit if we're not talking about cases or Alabama versus Vanderbilt football games. But thank you, Terrell. I look forward to diving into these questions and answers and just trying to educate some folks who may have questions about this.
Okay, thank you so much, Bernard. And we're also interested in getting questions from the attendees. So if you have questions for Bernard or for myself, you can put them in the Q&A section, or if you can't work that, put it into the chat section, and we'll do all that we can to get those questions answered for you. Now, so we've led off, Bernard, with saying that you do workers' comp, Social Security, disability, and today's topic, one of them is going to be workers' comp, obviously. What led you into that particular practice area, workers' comp?
Well, that's a great question, and it's one that I'm very fond of answering. David and I and our middle brother, Rob, who lives up in Virginia, we grew up in Dad's law practice. And as such, we saw the impact that he had when helping people who have been hurt on the job and really answering questions, taking away a little bit of stress by providing answers. He may not have the perfect resolution to these concerns, these stressful times, but what I saw was the difference that he was making in these folks' lives, particularly when they really needed it the most. That made a huge impression on me, and it did for David as well. So I knew that this was really a kind of a calling, and it's the kind of work that I've done my entire practice. I thoroughly enjoy just providing answers for people who are they're stressed out, because when you get hurt on the job, if you really think about it, all of life's stresses ramp up because it's your health, it's your livelihood, and as a result, it impacts your ability to communicate with your people in your world, your family, your spouse, your children, whoever it is who's relying upon you to make the money that you certainly have gotten to a certain level of livelihood, if you will. So you expect to be able to put a certain amount of money maybe in the bank, which in turn pays all those bills. But when you get hurt, all of that is disrupted because you don't know where your money's coming from. You don't know if you still have a job. You don't know if you're getting medical care. Well, my job, we've always found or always taken the belief is that it's not our first rodeo, so to speak. We've done this is what we do. We go get those answers for you. We tell you what the law is about. We tell you what's the likely scenarios in your particular situation, because every case is different. Every fact pattern is a little different. But we want to provide answers because we want to take a little bit of that stress off of you, because the fear of the unknown is the greatest fear. So if I'm an injured worker and I'm laying in bed and it's 2:00 in the morning and I don't know when my next check is coming in, so I don't know how I'm going to be able to feed my children. Well, that's what we're trying to provide, Terrell, is those answers for people.
That's really good, Bernard. And when I hear the foundation and the basis for that, you got into because your dad was helping people and you got to see people, so you know that when someone comes, that the lawyer has a passion for it and a care for and compassion for the people that you're dealing with. And I don't think you can get better service than from a lawyer that has that. And that's kind of how I got into, from a different side. My mom was actually hurt. She was, when I was 10, my mom was actually shot in the top of her head and left paralyzed. And she was no longer able to work or do much of anything for herself. And so I ended up helping her to do things, and that kind of planted a seed for me to want to go out and help people that couldn't do these things for themselves, and we're going to get into some questions about people needing help. And that's what this craft is about, in my opinion.
It's everybody has their journey, and what starts that journey I find so fascinating. I truly didn't know that about your mother, but now I see what drives you. And now I see how it is you've become as successful as you have and as dedicated as you are. But one last thing I want to share on this is one of the cool things that has happened for David and me, my business partner, my youngest brother, is that we're now helping second generation clients of our dad from back in the day. Their children or relatives are finding us with fond memories of the time that our dad was able to help them. So that's been a pretty cool product, or a little pretty cool thing that David and I have experienced.
Yeah, that is awesome. I know your dad is loving that because you don't know which direction your kids will go.
That's right. That's right.
So for you guys to take up that legacy and continue and further it is awesome. So now this is a question: what is the purpose of workers' compensation laws? Like well, first, is it federal, is it state, and then what's the purpose of them?
Well, we can look at both, but we concentrate on state. And what that means is these are the state laws. Alabama Workers' Compensation Act was codified many, many years ago. And there's a group of laws that have been on the books about 35 years. And unfortunately, they haven't changed much during that time period. And we could spend this entire hour just talking about my criticisms about why injured workers in Alabama aren't treated fairly. The bottom line is that Alabama's pay rates for injured workers is the lowest in the country. And it may not surprise a lot of people, but it hasn't changed in over 30 years. But the cost of living has skyrocketed in 30 years. If you think back to the early 90s, late 80s, things don't cost back then what they cost now, but the pay rates haven't changed. But Alabama workers' compensation laws are designed to be a no-fault set of laws that protect people who've been hurt in settings where the laws apply. There are certain types of employment settings where the Alabama laws don't apply. For example, working on a farm, not being an employee, but being an independent contractor. I could go on and on and on about those scenarios, but let's assume that you're an injured worker at an Alabama-based company. The Alabama work comp laws are going to apply to you. And when I say no fault, let's say that you pick up a box of supplies and you throw out your back. Well, the picking up of the box is what created your back injury, but you were doing it at work. So the laws will apply to you for compensation, for medical care, and the like. Now let's pause that for just a second. That's an Alabama employer. If you are hired by the federal government, let's say that you work for the Postal Service, and there's any number of federal-based employment settings in our state where people get hurt. That's a whole different set of laws. That's through the Federal Workers' Compensation Act. And we're going to pause that. We're not going to talk about that today. We're just talking predominantly for our talk, Alabama employment settings. So I hope that kind of gets us going a little bit where we are.
Yeah, that actually that's perfect because that's exactly what we want to talk about, these state laws. That's probably what most people on the CLE will be dealing with for the most part. Now, how does a workers' compensation case start?
Well, it starts when somebody gets hurt on the job.
Okay.
And we'll create an example here. We'll talk about that person who works in a warehouse for an Alabama-based employer. Now, there has to be 5 or more employees of the company. And let's look on the employer side of this first. If you have 5 or more, you need to have workers' compensation coverage because you're required to by law. If you don't, there are penalties, there are fines, and some real problems can result. But let's assume that we have that coverage, that the employer has properly filed with the Department of Labor, Department of Insurance, the workers' comp coverage in place. So when somebody gets hurt on the job, it has to be reported. If it's not reported timely, and there's 2 different types of what we call notice provisions. You can either give notice verbally by telling your boss or somebody within the management. You don't have to do it the exact moment that it happens or even that day. You have a couple of days that you can report it. However, What you don't want to do is fall afoul of whatever the company rules and regulations are. So if your company says, if you have an accident on the job, you got to report it by the end of your shift, and you don't do that and you report it the next day, if that's a terminable offense, you can be terminated by the company, but still have the right to work comp benefits. And I don't want to get too muddied, too deep into the woods unless there's specific questions about this. But the other type of notice, putting your company on notice, is you can actually write a letter, an email, something, a text. You just got to put the company, somebody in a position to do something about it. You got to let them know, hey, I got hurt on the job. Here's briefly what happened. And this is the really, really important part. I got hurt and I need medical care. It's not enough. And believe me, we've been through these cases many, 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 many times. I told them I got hurt at work. Yeah, but what about the second part? I got hurt. I had an accident. I got hurt and I need medical care. Too many cases get thrown out of court when the testimony ultimately plays out, the evidence plays out. Well, I never told him I needed medical care, but now 2 years later, we're into a lawsuit, and that's the testimony. Well, how do you expect the employer to read your mind? It's not up to the employer to go digging to ask all these questions. The good ones will, and the majority of employers will handle it and do it properly. But it's up to the employee to let them know, I got hurt on the job, here's what happened, and I need medical care. That's how it starts.
Well, that's good, because that goes into our can they do that? Because that would be something that a lot of people would be surprised that you have to tell the employer that I actually need medical care. You can't just say I got hurt. That's a big deal.
But what the reality of what happens is a lot of people are scared that they're going to lose their job, because we're an at-will employment state, which means you can be hired or fired at the will of the company for just about any or no reason, so long as it doesn't violate a federal protected class or something like that. But if today is red striped shirt day and you come in wearing a blue solid shirt, as ridiculous as it sounds, you can be terminated. Unless you have an employment agreement that spells out the terms of employment and the ways that you can be terminated, et cetera, you're going to be at will. 99% of us in the state are. So a lot of people don't want to tell because it's a job. It may be a very good high hourly wage paying job, and they're living paycheck to paycheck, but people are scared sometimes to report it. And I don't want to go too far afield of where we are, Terrell, but I wanted to say we actually have anti-retaliation laws that are part of the Alabama Work Comp Act, which means the company cannot retaliate against you and terminate your employment for the sole reason, and this is the key term, sole reason, that you're maintaining a work comp claim. However, if you violated safety laws safety rules within the company, and that's how you got hurt. For example, if you were driving a forklift and you were supposed to be strapped in with the proper harnesses, but you weren't and you fell out and that's how you got hurt, well, you could be terminated for that and benefits could be denied. So anyway, that's how you get started.
Well, thank you, Bernard. And that was actually, we're going to get to that a little bit later on, but
All right, we'll
since
pause.
you brought it up, no, that's a good place, because those are some important things about workers' comp and retaliation. Because I don't do workers' comp, but I will represent someone, and I have represented people on the workers' comp retaliation portion of it because it falls more into my wheelhouse of employment. Because it's a retaliation, and the retaliation is just based, the protected activity in a workers' comp claim, in a workers' comp case, is that you filed a workers' comp claim. But it is different than, say, Title VII, which has, it has to be a motivating factor. Your race, gender, all those things have to be motivating factor, or even age, where it has to be but for. Soul takes it down to, there can be no other reason, And I've had some success, and I'll give everyone an example of a time I've had success on proving that it was the sole reason, which is as hard as that sounds, because as human beings, we hardly do anything for one reason.
Mhm.
So you can imagine how high a hurdle that is. But I had a case where a lady got hurt. She fell in the break room and ended up hurting her ankle. She went and did everything that she needed to do. She reported it to a supervisor that day, ended up getting medical treatment. She was sent to the workers' comp doctor. And then they fired her afterwards, saying that she had filed a fraudulent workers' comp claim.
Mhm.
When questioned, when I'm questioning the higher ups at the company, no one had evidence that her claim was fraudulent,
Mhm.
but they said it was fraudulent. And so that one, we ended up being successful on that one because you essentially gave us that the reason that you fired her was because she filed a workers' comp claim.
Yeah.
And if you're allowed to, if every employer is allowed to just throw fraudulent onto it,
Mhm.
to avoid liability, we might as well get rid of the statute. So we were able to prevail in that case.
Yeah, that sounds like they just made up a reason.
Yeah, yeah. So now let's go into now if someone, obviously workers' compensation is a practice area for you and other lawyers in the state. If someone is hurt on the job, why would they need a lawyer to handle it? At what point would they need it to handle, or why couldn't the employer just pay their bills and pay their leave and let that be that?
Well, and we get asked that quite a bit. And my question or my response back, and this is not to be flippant, is why do you need a doctor? Why do you need an accountant? Why do you need any professional? Well, that's what those people are trained to do. You hire them to do the specialty that they know what their training, education, and experience is to guide you through it. An insurance adjuster's job is not to be your friend, no matter how friendly they may be in communications. Those insurance company buildings are big buildings for a reason, because those companies are worth a lot of money. They're not there to be a handout for you. So the insurance company's job is to resolve the claim of the injured worker for the least amount of money possible. So where do I fit into this? Where does a lawyer who has dealt with work comp cases come into this? Well, knowing the parameters of what is permissible for an injured worker for their rights my job is to protect those legal rights. My job is to make sure that the insurance carrier and its company follows those rules and provides you with those legal rights that you're entitled to, whether it's medical care, compensation, vocational rehabilitation, the list goes on. They're not going to tell you all those things. And they're going to, if you don't have a lawyer, what's the first thing that people do when they want to go find answers? They go to Google. Well, if you're reading laws that pertain to outside of our state in a work comp context, you're wasting your time completely. And the reason why I say that is Alabama laws are completely unique versus any other states in our country. We're the only state that still has a litigation trial judge based resolution to work comp cases. Most other states have tribunals or administrative law judges or panels. We go to circuit court. If we try a case in court, we don't have a jury. We just have a judge, but it's a circuit judge, the same judge that would hear a medical malpractice case or hear a car accident case or a business case. We've been doing this collectively over 100 years in our firm. It's not our first case when you come to us, but it's likely your first case when you come to us. Our job, again, is to guide you through that process. That's why you need a lawyer.
Perfect answer. That you could do a lot of things yourself, but I don't fix my car. I leave it to people that know how to do it. So that perfect answer. Thank you for that. Now, are there any requirements? We talked about the potential for people to have employment contracts. Otherwise, you're at will employee, which most people are. If I've given that spiel to a potential client one time, I've given 1,000.
Oh yeah, daily.
Yes, yes. And I let them know that you can be fired for anything. I need an illegal reason. I had this conversation yesterday. Give me an illegal reason, not something that you don't like. Our courts are clogged up enough. If they ever made being a jerk on a job illegal,
Yeah,
it'd be a lot more clogged.
that's right. That's right.
So, but are there any requirements for lawyers as far as the agreements that a lawyer has between someone that has a workers' comp claim and the lawyer?
Well, sure. The same laws that set the parameters under the Alabama Workers' Compensation Act, those codified group of laws that pertain to these cases, also set into place an attorney's fee and the things that between a client and its lawyer spell out. So attorney's fees are capped at 15%. So we have a contingency fee, which means we don't get paid unless we resolve your case. If we don't win your case, or if a judge kicks us out of court or whatever reason, there's no recovery. But it's a 15% recovery plus our case expenses. Case expenses are our cost of doing business, like ordering medical records. It's just there could be postage, copying, those kind of things. But I will say this as well. Those same laws that I keep referring to that apply to these cases that set our attorney's fees, we also have the lowest attorney's fees in the country as well.
And that's exactly what I was wanting to get to. So someone that's considering, a young lawyer is considering workers' compensation, where you can go into any other practice and your fee not be capped. Mm-hmm. How do you make up, I guess, for that? Is it a volume thing, or is it?
It is. It's a volume thing. There's never, and this is not meant to be disparaging whatsoever to any other lawyers who do other types of cases. Mm-hmm. You can have other types of cases that may give you such a large potential fee that you consider retiring off of that one case or that one groups of cases. That's not why we do what we do. We're capped at 15%. And I knew that going in, and this is the type of work that I have a passion and always have had a passion for. We have a large volume-based practice, and that's based on that and the diversity of our practice with Social Security, bankruptcy, and some personal injury cases. That's how we run our practice.
Perfect. Now we got a little heady. You may have answered this question already for me, but in employment discrimination cases, what we generally do is file a charge with the EEOC or a complaint of discrimination with the Equal Employment Opportunity Commission, federal agency. And we let them investigate, possibly mediation, mm-hmm. but eventually most EEOC charges end with a right to sue. You're given a notice of your rights and the right to sue letter. And we go forward. We have 90 days to file either in state court or federal court that employment discrimination case. Mm-hmm. In workers' comp, do you have any kind of administrative procedures that you have to go through before you get to circuit court, or you can go whenever you want with it, like any other type of litigation?
The Work Compact allows either the employer or the employee to initiate litigation. The employer can file, and sometimes they do this strategically, if they want to make sure that any disputed claims stays in their home county, as opposed to if there's a question whether there's a different venue where the case could be filed. So gotcha. Either party can initiate litigation. Terrell, I'd say maybe 25% of our cases end up in litigation, because the majority of them can resolve for the proper amounts or the best amounts for our clients without having to do that. You have a 2-year statute of limitations from the date of the accident. or in the situation where work comp checks, either weekly or biweekly, are paid, whenever those stop, you then have 2 years from that date. So there's many ways to get to the finish line. It doesn't have to always go through court. We can mediate with the ombudsman program. We can mediate with private attorneys, which we do more and more of those. So there's various avenues, but from an administration or administrative law part, there's not really something equivalent to EEOC or things like that.
Okay. Now, what I usually tell lawyers, we have lawyers that refer cases in for employment discrimination, for civil rights, for criminal cases, all kinds of things. But obviously, on the criminal case side, where there's a good client is, have you been charged with a crime, and can you pay a lawyer? That's the pretty much the basis there. But for these cases, for the employment discrimination or civil rights cases, obviously that we have to look at, is the case going to be viable? We have to look at the plaintiff and things like that. And I usually tell lawyers to send them on. If you get somebody that sounds like this, send them on to me, and we'll sift through and figure out what's what. But lawyers that refer, that are more repeat referring lawyers, they tend to get a feel for what I think is a good case, or what they know I'll turn down. So how does a lawyer that does not handle workers' comp cases know whether there's a potential case is a good case to refer to someone like yourself? And what are some things that you look for as far as it being a good case?
The worst thing that you can do is work up a case that's a work comp case, like it's a personal injury case. If you've read the Comp Act or know anything about comp, pain and suffering, emotional distress, lost wages, punitive damages, things that may be potentially viable in a trucking or car accident type of case, none of that matters. It doesn't matter to me the value of the unpaid medical bills. So sometimes what happens is somebody who we've never dealt with and maybe has never dealt with work comp, they think they've got a really good work comp case, and they work it up like it's a PI case. And then they get a little bit over their head, so to speak, and they'll call us up, and we kind of have to straighten it out a little bit. But I guess the best way I can answer that is, if they get hurt at work and there's an injury that requires medical care, just stop right there and call us. Let us pick it up from there. It's really that simple, because it'll be pretty quick. Our staff is trained that they can go through new cases for intake. They know exactly what we need in about 4 to 6 minutes. And if they can't get the information in 4 to 6 minutes, that's a red flag to us that there may be something there that we don't necessarily want to get into. But if they get hurt at work and they're needing medical care, just send them. Just give us a phone call, 205-930-6900, and just let our staff start the intake process. And then what we do, we'll schedule a phone call with them. If it's a case that looks like it's something should be followed up on, we try to schedule a phone call with if we can't do it that same business day, within 24 hours. And then we'll report back to the referring source, hey, this is what we think we got. We're going to sign them up, or no, this isn't one of those that we can go forward with, but thank you, for thinking of us, that kind of thing.
Well, thank you for that, Bernard. That answer had a few really good nuggets in there about, one wasn't even like related specifically to the question, but what you said about your staff. I think that's a big deal in having the systems, because you can get and efficiently vet those cases with 4 to 6 minutes, like you said. When your staff is trained, you have the systems in place to do that.
Well, Terrell, on a side note, that's when we hire new staff to be the frontline intake or dealing with our clients, we look for certain personality traits. Because if you don't have patience, if you don't have a little bit of empathy, and then also have a little bit of the ability to stop a conversation on the other end, even though they want to tell you their whole story. If you don't have those kind of qualities, it's tough for you to do this job, because you'll be on the phone 17, 18, 19, 30 minutes, and the phone calls just keep stacking up, you know? So anyway, we really work hard with our staff to be able to process those calls in 4 to 6 minutes.
Well, that's a good point. And now, is there for all the lawyers that are on, is there a place where you derive that system? Did you read books? How did you get the system for training?
It came from mentors ahead of me, people we learned from, seminars, books. It's just something that David and I have kind of created and shaped over the years. And we've been very fortunate to have our employees have been with us for several years. So we're very, very pleased about that.
Awesome. Now, handling civil rights, employment discrimination, the areas of practice, criminal law, the areas that we practice in our firm, we run into some quirky rules and case law that sometimes don't seem to mesh with common sense. Are there anything like that, or any things like that in the realm of workers' comp practice or in that area of law?
Only every day. Where should I start? If you want it from our client's perspective, let me give you a real world example that I used to just think, well, why aren't they thinking about this? Why isn't common sense dropping into here? Mm-hmm. Well, I think I figured it out several years ago, in that when a person gets injured on the job and they're dealing with doctors and they're dealing with employment settings and dealing with lawyers, that's not the norm for them. It takes some guts, frankly, for most people just to pick up the phone and call a lawyer, because they're thinking, I don't know this lawyer. Is this going to start costing me money that I don't have? They have these fancy titles, these fancy offices. Why do they want to help or talk to me? Well, one of the things that we have done, and when we really focus a lot of what we are at our firm, is we've got problems too. We're just like the guy or the gal on the other end of the phone call. We just didn't happen to get hurt at work. And we try to show them our human side, not our lawyer side until we need to do that. But once we break down those barriers that they may have, not all callers have that. Some do, many do. But what we try to do, once we've worked through that, and we can show them that we kind of know what we're doing a little bit, and we start into the process of representing them, hopefully after they watch our videos from our YouTube channel or see all of our social media, how we try to educate clients and potential clients. Some of the things, and I know this is a long-winded answer, but where I'm going with this is sometimes we'll have clients who will go to a doctor and the doctor says, all right, I'm releasing you back to work. I'm not finished with the medical care. We're going to start you in a sedentary position for the next 6 weeks and go through work hardening. Sedentary means they're sitting at a desk and processing mail or answering the phone. And the client will say, well, how's that going to help my case? Or is that going to hurt my case? Those kind of things. And what we always tell them is, and we start this at the very beginning of every representation, the client's credibility in a workers' comp case is the most important thing in the entire case. If the insurance company representative, the adjuster doesn't believe you, the defense counsel doesn't believe you, or the lawyer doesn't believe you, or the judge doesn't believe you, why should anybody do anything to help you in this case? So if the restrictions are don't do any roof work, and there's video surveillance of you climbing up a roof and cleaning out your gutters or retiling, where's your common sense? How's that going to help you? How's that going to allow me to help you? So they're scared. But if they really just kind of have that trust in the lawyer, that we're going to go through this together. Believe in yourself, believe what the doctors are telling you, and follow using that common sense. Hopefully you'll get through this, and we'll get through this a little bit easier, as opposed to me having to dig you out of a hole that you have dug because you're violating the doctor's return to work restrictions and limitations, because he told you, don't mow your yard until I release you, or, whatever. There's hundreds of examples. So I don't know if that exactly gets the common sense aspect of it, but it's you got to build that trust with your client so that they'll believe you on down the road, 6 months, a year from now. Because when they get frustrated that they haven't worked or their body's not functioning the way that it should be, who are they going to take it out on? Most likely it's going to be the lawyer, if you don't have that good relationship communication wise.
All good points. I really like the point about the credibility, because I think that is not just workers' comp, that's every area. Because especially earlier on in practice, I would get, and I think we're kind of conditioned coming out of law school to see a case.
Mm-hmm.
Like, okay, you have a case, it checks the boxes. I can get you past summary judgment, I could do these things, but if you don't have the right client, if the client doesn't have credibility, checking the boxes for summary judgment, I've been there where I checked the boxes for summary judgment, and I could foreclose the possibility I'm getting to a jury trial. And then when I stood up to make opening statement, and my client was actually, when she was actually on the stand, I thought, oh, this doesn't resonate. And that's a bad place to be, obviously, to find that out, to think about that. So I think that's a very good point.
Yeah, most of these people who reach out to us, and you and others who may be in this Zoom call, we all have clients who are in need of help. And that's why you do what you do. That's why you went to law school, probably. That's one of the motivating factors. And so they need people in their life that they can rely upon and trust. And their lawyer needs to be one of those people. And so communication is of utmost importance. Returning phone calls, responding to emails or text, whatever way you communicate with your client, don't leave them hanging. Because if you wait 3 days to call them back, all they do for those 72 hours is two things. They stew on it, on the matter, whatever it is, and then they turn it on you. They could put out a Google review that's horrible. They could start looking for other lawyers. There's a host of things. You got to take care of your clients communication-wise.
Very good points. Now, I when I first started practicing, Bernard, I had a case, and I didn't even think workers' comp. It wasn't even on my radar. A guy had been threatened by a coworker, actually. Mm-hmm. She told him she was upset with him about something that happened at work. She told him, well, okay, I'm going to get my boyfriend and some other people to come up here and teach you a lesson. So one day he's leaving, and the parking lot is dark, or the area where they have to go to park around the building is dark, and these guys come up and assault him. They do break bones, beat him up really badly. So I'm looking at that case from a premises liability and things like this, and I go to digging in it, and I come across a case, I believe it was Beard versus Mobile Press Register, where a guy, actually a coworker, shot his coworker. Like, he got mad, came to press register and shot and killed his coworker, and his family was suing for wrongful death, and there was no workers' comp claim in there. Court ends up throwing it out because they said the Workers' Comp Act with the exclusivity clause in it, that's where that should have been handled. Can you talk about that a little bit? Something that just it blew my mind back then.
Yeah, these cases, and we've handled several. In fact, I concluded one last year that's similar to this. When you have employee versus employee, or employee versus supervisor, or even a patron of the store or the facility versus an employee of the store, violence, all of those cases are very fact specific, but it hinges on, is there a connection between the violent act that occurred and produced injury or death and the employment of the person who got hurt? For example, if someone is coming to rob the store comes into the store and has a gun, and similar to what you were referring to, and it's a domestic relations situation as opposed to the robbery situation. If it's a robbery situation and somebody gets shot up in the robbery, that's going to be covered. They were doing their job at the time they get shot. But if it's a domestic relation, an upset husband comes into the employment setting and at the place of business, and he believes that one of the employees is having an affair with his wife and shoots him up, that's not going to be covered just because it happened in the employment setting. There has to be a nexus between the act that occurred. Can't be personal motivation is what I'm saying. There has to be a connection to the employment, not just happen in the employment setting. I handled a case a few years ago that happened in Jefferson County where a disgruntled employee came back as he had been terminated. He had been warned because he was sleeping on the job. He had been warned many times, do it again, we have to terminate you. Well, he did, and they did. Well, he came back to get revenge, and he was looking apparently for the supervisor who terminated him. But my client's husband happened to be in the line of fire, literally and figuratively. He was shot and killed. And that was found to be compensable because it was employment related, even though the employee came back, or the former employee came back.
That stuff is so interesting, because I think even in that Beard case, it came down to was it an accident, and what the definition of a workplace accident was, and it seemed, if I remember correctly, you correct me if I'm off on this, but if I remember from back then, it hinged more on, was it foreseeable by the employer versus whether, because we think accidents okay, well, that's not an accident. A guy comes and shoots someone, but is it foreseeable by the employer?
Yeah, it's Terrell, all of these are very specific. So you have to interview as many people as you can. A lot of times you have to wait for the criminal matter to play out, if there's criminal matter also ongoing, so you can get those statements or see how the testimony plays out. They're usually very emotionally charged, particularly obviously if there's a death involved, but each case is very fact specific.
Well, thank you, Bernard. Now I do have one more question for you, and then we'll open it up for any questions that we have from the attendees. Now, what advice would you give to a young lawyer that wanted to start accepting workers' comp cases or improve their craft if they're already taking those cases?
Well, gosh, there's so many ways to start or to continue your education. Go to seminars, speak at seminars, go to lunch with experienced practitioners, have your questions ready. Ask those experienced practitioners to borrow depositions and read those depositions of the injured worker, of the corporate rep, of the authorized treating physician. There's a whole host of those. There's so many things you can do. Try cases, get in there and make mistakes. but learn the Alabama Work Comp Act. That truly is the starting point, but it is highly confusing. So go to as many seminars as you can go to.
Those are good. There are a couple. I guess this was a year or so. Well, it was before the pandemic. So I was a guest lecturer for a law school class, and I came up with these 12 rules. I love Jordan Peterson's 12 rules for life.
Mm-hmm.
So I came up with 12 rules for lawyer life, and I was giving them to the students, and you just hit on two of them. One is when you said get out there and try cases and make mistakes. One of them was perfect is done is better than perfect. That was something that early on I struggled with when I had to, if I had to file a motion, I was like, okay, I know what I want to get done, but I don't know of a specific thing for this. So I would just ruminate on, okay, what is the title of this thing? And I don't have a box to put it in. And then I ended up being mentored by an older lawyer, and I would see him just write whatever he wanted, motion to do whatever. And there was no, like, it didn't fit into a box. So I was like, okay, well, that works. So done is better than perfect. So you'll sit there and you have, if you don't, you'll have paralysis by analysis. And the last rule that I gave to those law students was, don't become a lawyer. Remain a law student. Always be a law student. You're always learning your craft. You're always seeking to learn more.
It's the practice of law. You know, you learn something every day.
Yes.
The other thing I was going to also add to that you hit upon, most of the plaintiffs' bar in the work comp world in Alabama, we all know each other. There's a limited number of practitioners who do this on a large scale of their practice. So we all kind of know each other. Don't ever hesitate to pick up the phone. Hey, I'm just starting out my work comp practice. Do you have a motion to blah, blah, blah? Well, gosh, don't recreate the wheel, man. Call upon your colleagues. Take them to lunch. There's so many ways to gain that knowledge. But you're right, it's the practice. Just keep at it.
Yeah. And that actually hits upon another one, which was even when you think you know, ask.
That's right. That's why I have a business partner, my brother. Yes. Every day we're bouncing stuff off. Do you think? Yes. What about? How about? Every day.
Yes. Same thing with Chris and I send him my stuff and he takes the snark out of it.
That's great. That's great.
So yeah. So it's good, definitely good to have people to bounce. So if you don't have a partner, bounce it off other lawyers. People are willing to listen and willing to help you avoid pitfalls that they have had before. And they're happy to do it. I know we're happy to do it, and Bernard and other lawyers that we associate with.
Absolutely. Another thought is join the Birmingham Bar's mentor-mentee program. I've been a mentor for several years through that. I love that interaction. Join that. It's an active, I don't know if they call it a committee or a group, but they'll pair you up with an experienced lawyer, typically in your area of interest. And they have a criteria throughout the year you're meeting with them.
Yes. Well, we're getting close to the hour here, and it looks like you have done such an excellent job of answering questions, Bernard.
Or putting them to sleep. Everybody awake out there?
You have given them all the information, and the attendees have all knowledge and understand all wisdom.
Good for them. Maybe I need to call them for some knowledge.
I guess we'll wrap it up. I'm going to check the Q&A just to make sure, but we're going to go ahead and wrap it up. And thank you again, Bernard, for coming on and sharing all this information with us, and the attendees, we thank you guys again for attending. Remember, you're going to remember to get it to do the survey afterwards, get your CLE credit, and we'll see you back here again for the Legal Link Up Summer CLE season. The final installment will be next Friday, July 30th. So thank you again, and have a good rest of the afternoon and a good weekend.
Thank you, Terrell. Enjoyed it.
Thank you, Bernard.
On behalf of Terrell and McCants, thank you for joining us for the third installment of the Legal Link Up Summer CLE series. Please make plans to join us next Friday, July 30th at noon Central Time for the final installment, Up and Running, Business Formation Updates and Protecting Your Client's Intellectual Property. For those of you who want CLE credit, please click on the link that will appear once this webinar has ended. This will open the program evaluation. Please complete the information requested on the form and submit to receive your CLE credit. Thank you and have a great rest of your day.
So